This SB 1168 clarifies the circumstances when a juvenile commits a serious or violent crime so they may be committed to the Division of Juvenile Justice, the DJJ, within the California Department of Corrections and Rehabilitation. SB 1168 simply provides that if any of the charges found to be true in the most recent sustained petition are of the Welfare and Institutions Code, WIC 707B offenses, the juvenile may be sentenced to the GJJ. This is a common sense clarification for both to keep our community safer and to help ensure that juvenile offenders are properly placed to receive appropriate treatment and rehab services.
And Mr. Hoffman, you may start with your witness in support.
Sean Hoffman with the California District Attorneys Association. So in 2007, the legislature passed SB 81, which narrowed DJJ eligibility with the intent of stopping the intake of non-serious, non-violent youths into state facilities. And the state has largely succeeded in that regard. At the time SB 81 was passed, we had almost 2,500 kids in DJJ. We're now at under 700. However, a strict interpretation of the language in Welfare and Institutions Code 733 has led to some strange outcomes where juveniles who have serious and violent current petitions are not eligible for a referral to DJJ because they followed up that serious or violent offense with a non-707B offense. And the California Supreme Court has acknowledged that focusing solely on the most recently committed offense could lead to what they called arbitrary and potentially absurd and troubling results. Before seeking an author for this, we brought the language to the committee staff to make sure we were drafting it narrowly. We're trying to keep with the spirit of SB 81. So you'll find that the language does two things. It does not allow us to use priors in making someone eligible for DJJ. So if someone has a current petition that is all non-707B offenses, we can't go back to a prior petition that has a 707B offense and use that as justification to refer them to DJJ. And additionally, it requires that the 707B charge in the current petition be admitted or found true to avoid a scenario where, you know, a 707B could be alleged but not proven just for the purposes of trying to send that individual to DJJ. One of the issues raised in the analysis by the opposition was basically asking, well, don't DAs have the discretion now to just not file the non-707B offense? And I will say that the case that brought this to our attention was a case where a young man committed an assault against his grandmother causing great bodily injury, which is a 707B felony. After that, he grabbed her dog, threw the dog off of the balcony of the apartment, killing the dog, which is not a 707B offense. That was all in one petition. When it went to the court looked at it and said, yes, there's a 707B offense in here, but last in time was this non-707B offense, therefore this young man is not eligible to go to DJJ. Many counties do in their charging, they'll look at it and they'll dismiss that the non-707B offense, but it really depends on the case. There are restitution implications to that. The nature of that offense may be indicative of some other sort of underlying behavior, something where we want to make sure that that individual is getting some treatment or some services for that in DJJ. And so we think this is a common sense and narrow approach to fixing this sort of anomaly in the law, and would ask for your support.
Thank you. Do we have other witnesses in support? Any witnesses in opposition? I believe the public defenders, yes.
Thank you. Is one on? Great. Okay, thank you. I'm Garrick Byers. I'm from the California Public Defenders Association. We think that this is a problem that doesn't really exist. And it's actually kind of shown by the committee analysis here. the analysis shows, it quotes the district attorney's opposition. It says, and this is on page 5, it says it can bring about some absurd outcomes, but there's no examples in there. And I realize that it's excerpted. They can't have the whole district attorney's letter necessarily. But the example that is given in there is the MV case, which is exactly the case that the district attorney here brought up. He said, this is what brought it to our attention. Well, MV is a case, I'm not familiar with the case except through the committee analysis and the speech here. Apparently, the trial court said something that happened to the same grandmother, apparently in the same incident, but to the same situation, a little bit later, meant that the person's not eligible for DJJ, even though the main offense was a very serious one, a 707B offense. This is a case that's in the Court of Appeal. Apparently, there's no decision yet. So we don't know ultimately if there's a problem. The Court of Appeal is not known for absurd decisions, for absurd conclusions. Let's see what they bring out. If they say, well, if it happened an hour later, 2 hours later, to the same situation, the same grandmother, well, then they can't go to DJJ, then we have a problem. If they say, this is a single petition, this is really an ongoing series of events, and the main event there is a 707B offense, and he can go to DJJ, then we don't have a problem. There doesn't seem to be, I'm sure that people can come up with one or two other absurd examples if they look long enough, but there doesn't seem to be a lot of them. What SB 81 did in 2007 is it said that if a person committed a serious offense in the past and they weren't sent to DJJ, and they subsequently commit another offense that's less serious, they shouldn't now be sent to DJJ. It's true that they've committed more offenses, but they're not as serious. They're decreasing in seriousness. And if they didn't get the harsher punishment the first time, they shouldn't get the harsher punishment the second time. And it seems to be working well. We'll see if we get an absurd example out of the MV case, but right now this is premature. Thank you.
Thank you. Are there any other witnesses in opposition? Let's see if there's anybody on the dais who has a question. And Senator Anderson, did you want to address any of those points? Go ahead.
Through the chair,
Yes.
if you wouldn't mind allowing my witness just to address that one point, because it has appeared before the Supreme Court. So for clarification purposes, if you wouldn't mind.
Mr. Hoffman, you can proceed.
I would just say that the In Re DB case in 2014 is the case where the California Supreme Court established the interpretation that you do look strictly to the last chronological offense, and if that offense was not a 707B offense, then the individual is not eligible for DJJ, regardless of whether other offenses in that same current petition are 707B offenses. So we anticipate that MV will be in line with the California Supreme Court ruling that has been out there for 4 years on this point.
Okay. All right, any conversation from the dais? Do we have a motion? All right, the bill would be do pass to approps. And Senator Anderson, would you like to close?
I would, thank you. When thinking in terms of this bill, don't think in terms of punishment. Think in terms of getting the proper help for these young people. If the DA has to choose between what he charges and what he doesn't charge, then we miss the opportunity in the case of throwing the dog off the balcony, of addressing that problem. We miss the opportunity of helping that young person straighten out their life. Would only be looking at one issue as opposed to all the issues. And if we don't charge them, then we won't know that this is an issue as they work through the process. I want to think in terms of addressing the issues for the whole person And I believe that this bill allows us to focus on all the demons and allow that person to square their life around and get them the help and the programming that they need. So that's why I believe it's so important that we make sure that DAs aren't caught between choosing between charging for one item or another, but rather charge with all so that that person can get the help they need. So this is really a bill about compassion.
I will take that as the close, and maybe before Mr. Weiner walks out the door, we'll quickly do a roll call.
Skinner?
Aye.
Skinner, aye. Anderson?
Aye.
Anderson, aye. Bradford? Jackson? Mitchell? Mitchell, aye. Stone? Stone, aye. Weiner? Weiner, aye.
All right, we'll, of course, keep the roll open. And now